Good evening, ladies and gentlemen. This is the April 29, 2015 meeting of the Municipality of Anchorage Board of Adjustment, and I am Baron Pinchot, the chair, and I'm calling this meeting to order. First item is to call the roll. Madam Clerk?
Aaron Cuccio,
Here.
Dwayne Adams,
Here.
Robert Stewart.
Here.
Also present is Julia Tucker, Board Counsel, and Lisa Slusner, Municipal Staff Support, and we have a quorum.
Thank you, Madam Clerk. You have received a copy of the agenda. Would you take a minute, please, to look over this and see if there are any additions, deletions, changes that you wish to make? Anything at all? Or are you still working?
I'm good. Looks okay.
Okay, seeing no changes, the agenda is approved. First substantive item is number 4 on the agenda, minutes of previous meeting. And the first one there is the minutes of the February 26, 2015 meeting. And we've all had a chance to look at it. Are there any additions, changes, deletions? Spelling, you know that I'm always big on spelling of names, considering my own name.
The only thing I'd suggest is I need to abstain from this, having not participated or been
That
present.
is correct. That is a good thought. Mr. Stewart, leave it up to you and me.
Okay, I've just got a couple more things to check.
Sure. Take your time, please.
Did we mean to not include the subcategories under the issues?
I'm not sure I understand.
As an example, on what was number 7 was changed to 6.
Are you talking about the 6th whereas clause?
No, on the issue. That would be on page 4.
Page 4. Well, the numbering was changed.
Yeah. So, issue number, what we'd identified as 7 was number 6.
Correct.
And then we had, like, number 10 and number 11 number 10 through 15. Oh, okay, that works, because we deleted G. Okay,
Correct, yes.
I believe they're correct.
Okay. Anything else?
Seems to be on point.
Okay, I have no changes, additions, deletions, and Mr. Stewart apparently is good with the way it is. So the minutes of the meeting of February 26, 2015 are approved as shown. Next is the minutes of the meeting of April 2, 2015. And Mr. Adams, you were present at that.
I was.
So, we want to have your input as well.
My only comment would be on page 2, we made a motion and we discussed it, and then we made the motion again, clarified it, and it reads as 2 different motions and a third one, all of which had the same result. And I just wanted to know, is that form correct? That format as it reads?
Well, if you look at that carefully, you will see the first motion that you made was to
Memorandum
supplement the
planning.
record and add the memorandum from planning into,
So it shows the deletion of
The
memorandum
record.
planning, right?
and then that was corrected.
Okay, got it. So that reads well to me then.
Yeah. Okay. Anything else?
That's the only thing I have.
Adams? Mr. Stewart?
Just a second, please.
Sure.
No objections. Concur, as is.
All right. The only thing I have is that on page 2, under item B3, it says set hearing date. I believe we did set the hearing date tentatively, depending on the availability only of John Haxby. Is that correct? My memory serves me correctly, that's exactly what we did. With a final decision to be approved on July the 9th.
Okay.
In other words, a hearing date of 6/24 and the final,
Yeah, that's on page
decision.
3.
you know, I don't have that.
Well, if you look in the packet,
Look at this later one right here.
Oh, I see.
Bob sent me
Lisa
some
very cleverly
amendments.
changed things after she emailed it to us, right?
Bob sent me some corrections, and that was one of them.
Oh, okay, all right, that's fine. Okay. Yeah, that's good, then I don't have anything. Anything else, Mr. Stewart?
No.
Mr. Adams?
Nothing?
Seeing no additions, changes, deletions, the minutes are approved by unanimous consent. And we now come to old business, 5A. A reminder regarding the South Anchorage High case that will be heard by myself, Mr. Stewart, and Mr. Hagsby. The only item that is still to be determined is the council memo. And if my memory serves me correctly, Ms. Tucker was not going to participate in that. Isn't that right?
That's correct, and if you'd like me to give you an update, I will.
Please do.
As we may have discussed informally after the last meeting, with Barrett's suggestion to me, our first quarter budget revisions for the assembly included funds to retain a contract attorney to assist the board. And that first quarter budget amendment was approved last night by the assembly, subject to the waiting period for the mayor to exercise line item veto over the budget. So I will be soliciting assistance. Barrett has asked to participate and make sure that he interviews and talks to that person, and I'm not able to do that solicitation until the budget is finally approved. So that being said, I can't commit, and that's why I appreciate the board leaving these things as tentative hearing dates, because it will take some time for us to process and bring somebody on, and that scheduling should accommodate their schedule, because I will not be participating.
When do you anticipate being available to interview, together with me, prospective counsel?
Well, the mayor has 7 days to veto.
Yeah,
If he
yeah.
doesn't veto, then that's good. If he does veto, the assembly has 21 days to override that veto. So there's some preliminary time things back and forth. A couple of the people that you and I talked about have conflicts. That includes Jim Reeves and his wife Susan Reeves. On account of he's representing somebody in a case contesting the BOA that's now in Superior Court. One person that I identified and asked to and invited to attend part of the last meeting is out of town until May 8th.
Okay, that's Kitchen?
Yes,
I
Courtney
can't remember,
Kitchen.
Courtney Kitchen.
Courtney Kitchen.
Okay.
And so I'm more confident now that the budget has been at least preliminarily approved to engage in some informal solicitation and narrowing things down than I was before last night. I'm just not inclined to do an interview if my budget doesn't support it. So, so I figure after May 8th, we'll have things lined up, because I'm not anticipating that this will be the subject of a mayoral veto
No, I don't think so either.
in there.
Just to let you know, I will be out of town until the 20th. So any interview would have to occur after the 20th.
Okay.
But you and I can be in contact on this, and we'll see what we can do.
And you were gonna think of some additional
I
names.
know, and I have not been able to come up with anybody else. Mr. Stewart, you're an attorney. Can you think of somebody?
No, not with this expertise that we need.
Okay. Dwayne, can you think of anybody?
No. I know lots of attorneys,
We need somebody who's got
In this
some
field, yeah.
expertise in this area.
One of the people that
Clearly.
you and I talked about to include was Tom Clintner.
Yeah.
Who sat on this board, so I
Yes.
will follow up with him.
If you
I
would,
wasn't
please.
comfortable before.
I know.
But
Yeah.
I am now, so that's somebody,
Yeah, Tom was on the Planning and Zoning Commission for quite some time too. I served with him, and I would say he does have good expertise in the area, although the appeal process.
right. And then there's also another woman that we have used her services in that firm, in the same firm, the Retort and Bittner firm. And her name escapes me at the moment, but she's somebody that has done municipal work for many communities
Mhm.
in Alaska, including the municipalities.
Okay.
Would Tom Meacham be a possibility? You know Tom?
That's a possibility.
See,
You
he
know
has a
Tom?
lot of land
You
use
know-
expertise.
No, I have seen his name before, but I don't know him.
He has appeared here in a few cases, on a number of occasions. And that would be a good possibility.
And then I'll also ask Mr. Clintner if he, and Tom Meacham too, if they're for additional
Yeah.
names, because they seem to do, and as I explained to you, I would also appreciate the opportunity here to be looking at people who may be available to do other work in my stead for the assembly. My father is 98 years old, and so, and lives in Fairfax County, Virginia. So I plan on taking some time off. I've got a leave bank that's larger than I'm allowed to roll over anyway. And I am looking for somebody who is available not only to assist the Board of Adjustment, but also potentially available
Mhm.
to provide some services to the assembly when they're there. So I just let you know that I have that in my mind also. So it is important that they have non-conflict and that they may be, available.
Okay. So, as to item 5A, the upshot is that we don't need to take any action, but Ms. Tucker and I will be interviewing potential counsel. And the tentative hearing date of June 24 will remain a tentative date, depending on what we come up with. Okay? Any comment, any suggestion, any talk that we need to engage in on this issue? Mr. Stewart? No?
That looks like the June 24th date is going to be a tight date.
It does.
That may slip.
It does. It may very well slip. So we'll just have to wait and see what
And we
happens.
should be, did you say May 20th, which one of you would be
Back,
available?
yes.
Mhm.
Mhm.
Or after May 20th?
Right. Okay, we come then to item, I'm sorry?
Can I make a
Yes.
suggestion? I think in the interim, based on what Mr. Stewart said, that it may be helpful if the board is polled for some alternative dates now so that they can get them on the calendar. Not at this meeting because we know that there's a conflict, but it takes some time to get everybody to have that. Do you
Yeah,
think that
that-
that would be premature?
Well, I think it's a little premature, but to assist in an alternative date, we have already set aside July 9 as the date for the consideration of the decision. So if things should slip, and if they don't slip by more than 2 weeks, we could do it
Could use
July
that date.
9, presumably. And that would also be okay
It was
with
2 week
Mr.
buffer.
Haxby. So we have 2 weeks leeway.
I think that's
As it
excellent.
is.
That's an excellent
Okay.
point.
So we'll just, let's play it by ear, but
I
if-
just kind of panicked
Yeah,
because
yeah.
it was summertime and people make plans and.
we all do,
And I
yes.
forgot about, they reserved that July
Yeah.
9th date also, so maybe we should have that date.
As a
reflected
fallback
here
right
someplace
now.
also, because it's not reflected.
Why don't we add that and put in there as 3B, tentative consideration date. Consideration of decision. Date July 9, 5:30. Okay? Does that accommodate your concern?
Yes, it does. And
Okay.
I appreciate it.
All right. Any further discussion about this?
No, I think that gives a good 2-week buffer.
Yeah, I think it does. Okay, very good. Then we will come to the next item on the agenda, and that is the hearing on VOA Appeal 2014-5. And that it concerns Planning and Zoning Commission Resolution number 2014-058 for case number 2014-0119. And this concerns GCI, ZBA, AWN, conditional use permit for an antenna in the south addition of Anchorage. Now, you have seen the memo, you have seen the briefs. Before we get to individual issues, I would like to take a little bit of time to talk about this case in general so that we all feel comfortable with understanding each other and finding out where we are in a way, so that we can talk in general terms about the case rather than in specific discussions. Yes, Mr.
Would the chair mind going ahead and doing the hearing panel members' disclosure of potential conflict of interest?
Oh, you want to do that again? Okay, all right. Is there any potential conflict that any of the two of you have, and then myself, regarding this particular case that I just called?
You know, the only thing that I see is that probably a number of us may be clients, or, you know, we're
Well,
retail users of the
GCI.
services.
Okay.
Yeah, but
Well,
that's
I
not,
don't think that qualifies as a conflict.
but that is not going to affect my ability
Okay.
to make an independent decision.
All right.
Yeah,
Mr. Adams?
I do live in this community council. My office is 3 blocks away from this particular site, but I have no interest, fiduciary or any other way, with any of the parties involved in this.
Okay. All right.
Is there anything that would keep you from putting the public interest above any other interest that you might have?
None.
Okay.
And then the other opportunity that we have before hearing and that other boards and commissions do is a disclosure of any ex parte contact, and that's the real purpose for having the item on the agenda here as an opportunity, because from time to time, people are approached or have contact, and it's the opportunity to disclose that and have it dealt with on the record.
Okay,
Is that
so,
right?
yes, so the question is, has any one of you, and that includes myself, had any ex parte contact with any of the parties to the appeal?
None.
Other than to welcome a couple people when they walked in tonight.
Okay, all right. Well, I can affirm that I have not had any contact, and I do not have a potential or actual conflict of interest in this case either. All right, does that satisfy your concerns?
It does, thank you very much.
Good, okay, all right. So let's get back to the case then. As I said, before we get into individual issues, I would like us to talk in general terms about this appeal. And I will simply start out, and maybe that we'll get some discussion going. As I see this appeal consideration develop, there are a couple threshold issues here. And the first one consists of the issue of the 14 omitted written comments. And I must tell you, when I first heard about this, I was taken aback by this. I mean, how can it be that staff suddenly leaves out written comments? I mean, it's fundamental that everybody who is entitled to comment on a case should have the written comments included, of course, and they should have been included in the packet, and I think everybody acknowledges that this was some unfortunate oversight. For us, the question arises, and this is the first thing I want to discuss and get resolved, is whether this rises to such a serious level that we need to take some action, or whether this is really de minimis under the circumstances of the case. Not that, as I said, that the omission of written comments is de minimis, but in the context of this particular case, it may very well be. So that's the first issue I want to discuss, and that's a threshold issue. The second threshold issue, before we get into the substantive issues, is we were alerted by the appellant that there was a case in 2010 in which the waiver issue arose as well, and in that case it was handled differently. Now, the 2010 case is not, and the minutes and the resolution are not part of the appeal packet, and so unless we do something, we cannot consider that. The way to handle that, and the way we have handled that in the past, is that we have taken judicial notice of other matters, and there is a procedure, and it is a well-accepted judicial doctrine that the decision-making body can take judicial notice of other items, and so we could, if we wanted to, take judicial notice of that case, and that was a 2010 case. So that is the second preliminary threshold issue that I want to discuss. And then, of course, we get into the nitty-gritty of the case itself. I should remind you that what is not being appealed in this case is the decision of P&Z to approve the conditional use. The only reason that this appeal and the conditional use was really defeated was because P&Z ruled on the issue under 2145 265A16C and denied a waiver of the what do we want to call it for simple use here is the waiver of the fall zone, and that's really the crux of the issue, the crux of this appeal case. And so the first thing is, do we affirm planning and zoning as is, or if we don't affirm the decision and thereby dismiss the appeal, what should the appropriate remedy be? Now, our board has several options. We can either remand under certain circumstances that are defined by ordinance, or we can reverse the decision of P&Z, or we can modify it. Those are basically the three options that we have. And so as we get into various issues, we will need to keep those options in mind. Assuming arguendo that we decide to modify P&Z's decision, which we have done frequently in the past, we will then get into the decision that P&Z reached in this case, and we will need to discuss the specific changes that will need to be made to satisfy us and to turn this into a final decision that can then be appealed further to the Superior Court if any of the parties wish to do so. So that's how I see this case developing and the discussion developing in this case. And now that I've talked a lot about this, I would like to hear from the two of you, Mr. Adams and/or Mr. Stewart, what your thoughts are in general terms, how we should approach this.
With respect to the three issues, I guess, I think the question is, I have not read that input because I didn't, if that wasn't available, I felt that I should not be reading that information. So the question is it germane to the case? Would it have been germane to the case, and would it have provided additional information that we would not otherwise have had?
Yep.
When I look at the record of appeal and the minutes, and I compare that against the conditional use standards, it appears to me that all those issues that should be addressed by the Sears, in this case Planning and Zoning Commission, on a conditional use process, anything that was identified in this issue does seem to have been reflected, and in fact it was quite iterative. There was actually 3 or 4 points, and despite the rather elaborate amount of information that was provided, they were iterative, and in fact some appeared to have been somewhat rote and was provided. So with respect to that, did it provide, do I feel that it is germane to the case? I believe that there was enough information provided.
Okay,
to provide that.
let's just talk in general terms because there's
Okay.
no motion on the floor at the
Right.
present time. I simply want a general discussion
Okay,
on how I view this case in the appeal discussion developing tonight.
right. There was a second one, the case identified in the appellant brief. It would seem to me the information as it was presented that has some veracity to the extent of what was provided in the packet, and that's what we have to weigh, is what was provided. And it's a relatively simple point, actually, is that it was handled differently than it had been handled before. And with respect to that, that affects the case. So it's really that one singular item, without getting into what the minutes may have said, how they came about that decision. So we have to deal on that level. And so to the level that it's presented, that our decisions can be based on that. And there's the fact that we don't have any additional information, it was not made part of the record, really isn't germane.
Okay.
The third item, which is that of the administrative official, is I don't know how far you want to go into that at a general level, but having been on the commission, there's really only one other. Well, let's start. Planning law, and for petitioners and the public, it's very important that there be a tiered process, and that tiered process reflect the degree to which the decision affects the public and the public at large. So there is a very carefully crafted, in most cases, tiered process for this review. There is administrative review, there is non-public hearing, site plan review, or non-public hearing items. There are public hearing items, and as we rise through there, then there are planning and zoning condition, or planning and zoning commission, and the urban design commission, and the planning board have very distinct roles. And there's a very careful distinction of the responsibilities and the roles of each. And that's very important to planning law and for petitioners, again, in the public, because there needs to be an expectation of what that process is and what's going to be followed. Now, with respect to the Planning and Zoning Commission of conditional uses, this is an anomaly. But there is one other case where this does exist, and that's where planning and zoning cases, conditional uses, and site plan reviews also involve plating. Title 21 is very specific with respect to how that is handled, and it provides a simple caveat that if the commission that is making that decision determines that they would like to have jurisdiction over the plat, they can assume that role. So it maintains very discreetly and very distinctly that tiered process. So this is just this outlier, this anomaly that from all practical purposes seems to be located in the wrong place and should have been 2 paragraphs before, and all this would have been resolved. Or if it had simply said that in the case of a conditional use, the role of the administrative official to review this is deferred to the Planning and Zoning Commission. Now, so that's the realm we're working in. My expectation is that staff knows that this is an anomaly, and and we can't ask staff that, but that they know that. And much like with the plating case, similarly, in the plating case, it's deferred to the Planning and Zoning Commission to make that determination. And in my 6 years on the Planning Commission, we always heard the plat. It was never deferred to the Planning Board, because what you're trying to remove is that case where a lower body may have the opportunity to override something or conflict with something that then kicks it to a panel such as ours. So staff probably somewhat astutely said, let's not get into that, let's avoid that, very possibly related to the very case that's cited. And as a result of that, having possibly been in a bind of our hands are tied, a conditional use has been provided, we can't contradict the use, let's just let the body who does that provide for that so that there is a consistency in the way that that's decided. And my guess is that works pretty well until they aren't consistent in their finding. So that's, I think, where we are on that.
Okay. Mr. Stewart?
I think, and I can't put my finger on it right now, but that case was in fact mentioned twice somewhere, either in the record or in the transcript. So I think it was by
Didn't see that.
twice, I believe, and I can't find my notes on it. So it
Okay.
looks to me like that was in fact, since it was addressed.
So what you're saying is really we may not need to take judicial notice.
No, I don't
Of
think
this
we
prior
have
case.
to, if I can.
If you can find it.
just-
I must tell you, I did not see it. I don't think our esteemed counsel saw it either.
It was mentioned, oh man,
If I could
Well-
respond.
Yeah, go ahead. Ms. Tucker.
I'm not sure if I recognized a reference to the case, to the prior case or not, but even if there was a reference to it, then that would support, not detract from, taking official notice of that case, in my view. And so I would always err on the side of caution.
yeah, so when I found those couple references, initially I was looking at it and saying, well, this obviously is something that was not part of the record. But there was discussion about it, and they were trying to tie down the exact address that was affected. And then there was some discussion back and forth about the exact location. And then it was tied down to an exact date, and the date coincides with the information.
Does it?
Yes.
I remember seeing the discussion about that location. Yeah, I thought it was a different location. I must
No,
tell you, I
it
didn't
was
pay
referring to
attention
this particular
to that.
case.
Okay. Anyway,
So-
be that as it may.
But I thought initially that was going to be
Yeah.
something we'd have to address, but in my view, I think it's okay to have that incorporated by reference.
Okay, well, we can discuss that when
yeah,
the
and,
motion comes up.
The other part, when I looked at the administrative functions, in other words, the ability to, or the option to waive that 200% from the height and the various structures that are on residential, protected residential districts. It looks like everything in there, in that particular section, reflects the same information that is available when you look at the section that deals with the review for the, what am I thinking?
Conditional use?
the site plan review. It's exactly the same. So I looked at that and I thought, well, they both mirror one another. So it looks to me like it's artfully drafted, no doubt about it. But it looks to me like they're looking at the exact same language. It's the information that goes to the applicant, information that goes to the owners, and obviously there's within a 500-foot boundary or diameter or radius of the facility, and then to the concerned community council. And then there's various due process that's associated with that I think it's section 14 rather than 16. So I looked at that and I thought, well, this seems to mirror it, and it does look like it's the exact same phrasing. So I interpreted that as they're implying that this is part of that administrative review process, rather than going through the formal conditional use under the Planning and Zoning Commission.
I think there's one other thing that I think supports that to some degree, and that is that the language with respect to the 8 or 9 items in 280, whatever the paragraph is, specifically provides for the Planning and Zoning Commission as part of the conditional use process to provide a waiver for standards that are necessary to meet condition and provide for the conditional use. So it uses that term waiver. And the only other place I see the waiver used is in that other language,
Okay.
dealing with the administrative site plan.
All right, we'll have an interesting discussion regarding that.
So it's a little different than I think what originally I'd thought about it, but as I looked at it more and more, I saw that mirror, and I saw the issue of due process in there
Okay.
for affected individuals, affected parties. And the only way you can get that due process is for it to become part of that site plan review or become part of the planning and zoning. Otherwise, you run into due process issues.
Okay, well, we're going to have a lively discussion. Yeah. All right, anything further as preliminary issues? Anything else you want to mention? Seeing none, let us get into the first threshold issue, and that is the omission of the 14 written comments. The way this was raised was that we suddenly got a memo from staff groveling and saying these were omitted. And the question is what to do with it. So in order to raise this, I would like to entertain a motion regarding this. Does the fact that the 14 written comments were omitted, does that affect in any way the posture of this case? And remember that my druthers are that we do not phrase motions in the form of a question, but in the form of a statement that we can then say yes or no to, or vote yes or no to. So I will entertain a motion that we disregard the 14 written comments, just to bring the issue to the floor. Anybody willing to try his luck on making that motion?
So you're looking at just disregarding it, or
Disregarding the 14 written comments that were identified by the staff memo of
Okay.
whatever the date was. I don't have it here
Oh.
off the top of my head. Oh, here. Here it is. Oh, it's April 1, 2015. And I take it, Mr. Stewart, you're making that motion?
Do you want me to give it a little more detail?
Why don't you just make the motion,
Okay.
and then we will discuss it, assuming there's a second.
Move that the inadvertent omission of 14 written public comments from the staff report provided to the Planning and Zoning Commission at their hearing of October 13th, 2014 was not a substantial procedural error requiring remand to open the record for inclusion and consideration of the omitted statements by the Planning and Zoning Commission. Second.
Second.
All right, it's been moved and seconded. Mr. Stewart, would you speak to your motion, please?
Okay. As you mentioned, the planning staff gave the parties and the Board of Adjustment notice of the April 1, 2015 memo that approximately 14 comments were inadvertently omitted. And the Board of Adjustment gave the parties an opportunity to supplement the briefing on the issue of omitted written comments from the public. Over 4 dozen written comments were included in the materials made available to the Planning and Zoning Commission at the October 13th, 2014 hearing, and about a dozen members of the public testified. I want to make a note that the content of the omitted material is not something that is before us as part of the record. What I am considering the names of the people and the dates coincided with their appearance, not the content of what they said. Of the approximately 14 members' comments inadvertently omitted from the materials made available to the Planning and Zoning October 13th hearing, 2 of the public members submitted appellate briefs, and 5 of the public members either testified or filed prior statements that were included in the record provided to Planning and Zoning at the October 13th, 2014 meeting. That's a significant portion of the 14. And I think that there's substantial evidence in the record that supports that actually is supporting and non-supporting approval of the conditional use application. And I also note that there was no claim of evidence or claim of prejudice related to the omission. And I think that the Board of Adjustment should determine that the omission is harmless error and concludes remand is not necessary as a matter of law.
Mr. Adams?
I would support that as it was stated. Both the appellee and the appellant had the opportunity to respond. The appellant did respond with additional information, but it wasn't really germane to that issue. I think Mr. Stewart has laid that out quite well, actually.
Okay. Let me add my 5 cents worth. I intend to vote for the motion. And we have had our esteemed counsel's memorandum in that. She addressed this issue as an alternative, and when we turn to page 6 of her memo, there are some suggestions there. And I wish to read those into the record because those are my findings regarding this particular issue. Number 1, planning staff gave the parties and the Board of Adjustment notice dated April 1, 2015 that approximately 14 public comments were inadvertently omitted from the materials made available to the Planning and Zoning Commission at the hearing on October 13, 2014. The Board of Adjustment gave the parties an opportunity to supplement briefing on the issue of omitted written comments from the public. 2, several dozen written public comments were included in the materials made available to the Planning and Zoning Commission at the hearing, and a dozen members of the public testified. 3, there is substantial evidence in the record both supporting and not supporting approval of the conditional use application, and there is no evidence or claim of prejudice. And number 4, the omission is harmless error. Any further comments regarding this threshold issue?
The only comment I have, Barrett, is on the issue number 2, several dozen. That could be interpreted as 3 dozen, when in fact it was over 4 dozen.
All right. Any additional comment? Mr. Adams?
None.
If not, please vote.
Aye.
We need
She'll take a roll
to,
call.
Oh.
she will need to call the roll. I'm sorry, Mr. Adams.
Baron Gutschall,
Yes?
Robert Stewart,
Yes?
Dwayne Adams.
Yes.
All right, the motion passes 3-0. And the findings of fact supporting that decision are the comments of Mr. Stewart, Mr. Adams, and myself. Second threshold issue that we need to attend to is the official notice of planning and zoning case 2010-97, resolution, P&Z resolution 2010-33. And I will entertain a motion that in considering this appeal, the Board of Adjustment take official notice of P&Z case 2010-97/resolution 2010-33.
So moved.
So moved. We have a
Second.
second. Mr. Stewart has been moved and seconded to take official notice of the case that I mentioned. Mr. Adams.
The case that's referenced, I think as I mentioned before, in my view, the information that's presented is presented at face value. It does not provide anything except a factual statement with respect to the disposition of that case. It does not provide any background with respect to what the findings were necessarily, other than how it is directly related to this case. And so as a straight line interpretation of how it is germane to the case without trying to influence any other discussion.
So are you in favor of the motion?
I am in favor of the motion.
Mr. Stewart.
I agree that the motion, or the case reflected in the motion, really doesn't give us a lot of information except what the findings were and how they voted, but it doesn't give us the reasoning why they did certain things, which would be very helpful, and I would hopeful that we could see that, but apparently that's not possible, so I will be voting in favor of the motion.
Okay. Any additional comments? Let me throw in my 5 cents worth. We have previously, in other cases, considered supplementing the record, because as we know, we are usually limited to the appeal packet. And what we have said in prior cases, in prior decisions, I wish to add here as findings of fact in support of the motion that I intend to vote in favor of. A, the Board of Adjustment doesn't conduct evidentiary hearings pursuant to AMC 2130-080. Any party may file a timely application for rehearing by the Planning and Zoning Commission based on the new evidence as provided in AMCR 2110-503. Allegations of new evidence shall not be considered or decided by the Board of Adjustment pursuant to 2130-040. In this case, no application for rehearing was filed. AWN has filed an exhibit outside the record on appeal, unless this board specifically takes official notice of the exhibit. The party's supplemental documents should be rejected as outside the record on appeal as per 2130-080. Now, I note here that Mr. Stewart alerted us to the fact that during the discussion of this case by the Planning and Zoning Commission, there was reference to the prior case. Now, the difficulty with that is that simply reference to the prior case does not give us access to the documents. And so if we if we take judicial notice of both the minutes at which the case was heard and the minutes of the meeting at which the decision was approved, and we take judicial notice of the resolution itself in that case, it will give us some understanding of what prior practice has been. It is true that staff never described it. When you look at the packet in this case, it simply says, you are going to sit here as an administrative official. No explanation as to how that comes about, and simply stating it as a fact. Well, the real issue that I had was, where does this come from? And as we will discuss later, there may not be anything in the code relating to this, but at least we have some guidance as to what was done before, and I think that is important as we consider the appeal itself. Remember, it is only the second issue that's on appeal. So in order to assist us in the interpretation of the code and the decision that was reached here by the Planning and Zoning Commission, I think it is important that we have before us the record of the prior case, both in terms of the minutes and the resolution, and it is for that reason that I will vote in favor of the motion and will vote in favor that we take judicial notice of that prior case by way of minutes and resolution. Any further discussion? Seeing none, Madam Clerk. Ms. Tucker, I'm sorry.
Thank you. I did prepare, just for efficiency, in case this came up, an excerpt of the minutes so that you have the first page, the last page, and then the discussion in both of those meetings of that prior case. And you may wish to consider that as a record of, as the record for inclusion.
Well, I must tell you, my druthers would be, you had previously provided us with a complete set of minutes, and the appellant provided us with the complete resolution in that case, and so I would prefer, quite frankly, if we simply incorporate the entire minutes and the entire resolution
That's no problem.
as it was presented to us. And I assume, from a practical point of view, if we vote in favor of this motion, that somehow this will get attached. Isn't that
Yes.
right?
Yes.
Okay, and you will see to it that that gets
Yes.
accomplished?
Yes.
Ms. Tucker?
Yes.
Okay,
Yes.
very good. All right, any further discussion regarding the motion? If not, Madam Clerk, would you please call the roll on the motion?
Baron
Yes.
Robert Stewart,
Yes.
Dwayne Adams,
Yes.
And the motion passes by a vote of 3-0. And Ms. Tucker has told us that she knows of some way to incorporate these documents that I previously referred to. All right, we then come to the more substantive matters here. And the first thing that I see here is that we need to discuss whether there was an error committed by P&Z as alleged by the appeal, that it assumed the role of the administrative official, and whether that was correct or not. And so I would entertain a motion that would be as follows. The Planning and Zoning Commission conducted the hearing of October 13, 2014, under the mistake of law that it could decide the fall zone waiver under 2145-265A16C. And since we are only three here, and by way of rotation, I will make that motion, and may I have a second, please?
Second.
Thank you. Just jot things down, and then I will talk about the motion. All right. It is my intention to vote in favor of the motion. To my way of thinking, there's nothing in the code that authorizes the Planning and Zoning Commission to act on behalf of the administrative official. The case that we just took judicial notice of gives us a little bit of guidance how this has been handled before. In case 2010-097, the Planning and Zoning Commission recognized the decisional division between the Planning and Zoning Commission and the administrative official on tower applications and made the tower approval conditional upon the administrative official waiving the fall zone requirement. And I think that needs to guide us in this case. It's my view that the Planning and Zoning Commission should have followed that earlier case. As I said, there is nothing in the code, and we specifically asked our counsel to look for it since we didn't find it apparently, and our counsel hasn't found it either. It simply doesn't exist. And whether that is a drafting oversight or whether this was intentional, I'm not sure of. But to my way of thinking, the consideration of the fall zone waiver by the Planning and Zoning Commission was an error. And that's not an error of procedure, that is an error of substantive law. If you look at it is simply internally inconsistent to say that the Planning and Zoning Commission can assume the role of the public official here. I don't think it should have happened. Planning and Zoning Commission preempted the administrative official in this case. And where you can see that also is when you look at there is a provision in the code. If we were to follow the logic of planning staff that the Planning and Zoning Commission can assume that role of the administrative official, what then is the meaning of 2145-265A14H, which provides for an appeal from decisions of the administrative official. In other words, it's the Planning and Zoning Commission that acts as the appeal body for the decisions by the administrative official. And it seems to me that's perfectly logical. And when you look at the provision in 16C that the administrative official is to make the decision, if he decides one way or the other, any party affected by it can appeal. And the appeal pursuant to 14H is to the Planning and Zoning Commission. Well, by doing it the way they did it, they really preempted the appeal to the Planning and Zoning Commission. That's really what happened. And if that were correct, then an appeal from that doesn't lie to this body, it lies to the Superior Court. Because there's a specific provision in 14H that says you can appeal the decision of the Planning and Zoning Commission in this particular case, where it acts as an appeal body to administrative official decisions. That appeal is to the Superior Court, not to the Board of Adjustment. You see. And it would be totally inconsistent and totally incongruous to say an appeal from the conditional use permit goes to the Board of Adjustment, but an appeal from the administrative waiver is reviewed by the Planning and Zoning Commission regarding the fault zone. Where's that go? It shouldn't be going to us, you see. And so because of that inconsistency, that to my way of thinking buttresses the fact that they simply misapplied the law. There is no provision that allows the Planning and Zoning Commission to assume the role of the administrative official. And to my way of thinking, that was a substantive error that in some way needs to be corrected by this board, and it is for that reason that I intend to vote in favor of the motion. Further discussion. Mr. Adams.
I think it's simply drafted as in the wrong place. I believe that provision specifically applies to the site plan review. Everything about that speaks in the same language and in parallel language as it would have applied to the site plan review. That's not before us, though. My belief is that if we look at 280C, 2150 280C, it specifically says that the Planning and Zoning Commission is supposed to look at things such as the height of the proposed structure, and it has language to issue the conditional use and provide the ability to waive or reduce the burden on the applicant. So it doesn't necessarily reflect a 200% rule, but that criteria is in here, and the Planning and Zoning Commission can choose to use that or not. It doesn't matter. And I do believe that it's a failure in drafting. It's in here, though. I believe that planning staff was looking for an elegant solution in the true belief that the authority that would pass such a thing would certainly have the prudence to provide a finding on the second matter to basically ratify that. But that did not happen. And how they could reach that logic and not reach the same conclusion befuddles me, but that doesn't matter because what you say is germane. We don't have the authority to change that. It may have been an elegant solution, but we don't have the power to change that. So it is the way it's written. And until such time as the Assembly changes this code, that's what we must comply with. It is very specific with respect to what the duties and responsibilities of an administrative official are and who that person is. Mm-hmm. And unlike the provision that provides for platting authority to be assumed by the body that's seeing the conditional use, mm-hmm. that language doesn't exist. Mm-hmm. If it existed, everything would be good, but that's not the case here. And so I do have to agree with you, and I'll be voting yes.
Okay. We are operating, oh, by the way, we should have mentioned that what applies in this case, as was stated somewhere in the record, it's the old code, it's not the new code.
Correct.
Do you know by any chance, Mr. Adams, whether the new code has corrected this?
I don't know.
Or whether this oversight was continued into the new code?
I don't know.
Ms.
That's
Tucker.
a good
I looked
question.
at that, and the oversight was
Carried
rolled,
through.
Forward, and I did have the opportunity, just coincidentally, on that issue, to speak to Tom Nelson, who happened to come by the clerk's office when I was there, and he explained that at the time, it's peculiar to the cell tower stuff in particular, and that the old code was sort of a conglomeration of PlaySaver and it was going to be rolled forward and taken care of and really thoroughly looked at with recommendations for all the things of internal consistency
that were done, right.
and all that in the new code, and it just didn't happen all the other things that were going on, and the Assembly hasn't addressed it.
Okay.
And it comes before the Assembly, rather piecemeal.
We need to, what that points out is, and we're really transgressing here somewhat from the motion, but what it really points out is this is not the first time that we've discovered drafting errors. We must come up with some kind of a mechanism to bring it to the attention of whoever is in charge of making or suggesting modifications. Because I agree it is something that needs to be addressed by the code. It's no longer terribly germane because there will be fewer and fewer cases under the old code. It will be mostly under the new code anyway. So I think it is very appropriate for us to keep that in mind later on. Mr. Stewart, any further discussion regarding the pending motion?
I just needed to clarify, on the first part of your motion, did you say that the Planning and Zoning Commission did or did not conduct a hearing under a mistake of law?
Did.
Did, okay.
Any further discussion?
If I may
Mr.
understand, when
Adams.
we say hearing under, are we talking about the hearing on the second matter or the entire hearing?
No, on the second.
The second matter on
The second matter.
And
Yeah.
does that need reflection, or is that okay?
needs to be a reflection in the motion, so it should say properly, the Planning and Zoning Commission conducted the hearing of October 13, 2014, under the mistake of law that it could decide the fall zone waiver under 2145, 265 A16C in lieu of the administrative official. Okay? And the motion should be worded that way. And Ms. Tucker, you had a comment before we vote on the issue?
I would just want the board to make sure that there's not an inconsistency between the way that the motion is worded and the commissioner's reflection and comment and discussion that the Planning and Zoning Commission does have authority under 2150-280C to have waived it, but not as sitting as
Correct.
the administrative official. So I think you captured
Correct.
that, but
Yes,
I just want
correct.
to make sure that the discussion
Yes,
on the
and
record.
that the record reflects that, and that our decision reflects that.
Yes.
Okay? All right, any
Um,
further discussion, Mr. Stewart?
I have a couple more questions.
Yes.
I'm in agreement that this is substantive error with what they did, but by incorporating the other case, are we inferring then that the administrative official, when they do act, is it optional or is it ministerial? Which they're just going, it's a matter of fact because what they're doing is they are then complying with the conditional use permit.
Who is they?
The
Administrative official, you mean?
official, right.
Yeah, I think it's mandatory. It's not optional under 265A16C. It's not optional.
Yes, it
It's
is.
optional. It's optional under the section that Mr. Adams described, but that's not the way they ruled on this. They simply said under 265A16C, you can act here and you can be the official under that section, and that's not correct.
Right. So my follow-on to that is then the next question is if the administrative official can act after a conditional use is granted,
Yes.
Or
Is
must
it-
act.
or is it
must act, because
Okay.
it's, in the
So
previous case, it was done as a condition of approval, really. You see, that he must waive it. And if he doesn't waive it, the conditional use is out the window.
Okay, and see, there's my problem. Because if he doesn't waive it, And then that person, the administrative official, voids
Yes,
the planning and zoning commission decision.
that's true, but remember, there's an appeal provision there. And the appeal goes back to the Planning and Zoning Commission.
Well,
You see, so they
but
get
in
a
that
second bite
case-
out of the apple, you see.
May I interject?
Yes.
Yes.
I think that it's important for the board to consider that as the commissioner has pointed out, in some instances, not in the previous case, but in some instances, under code, the Planning and Zoning Commission has the authority under code to make that determination. And they just go ahead and make it. They undersee, they grant the conditional use, and in so doing, they are making the waiver. End of story. Whole complete, they don't
Mhm.
leave out
I
anything,
agree.
that's it. And if that happens, there is no need for anybody to go over to the administrative official. That administrative official provision is optional. It's written in optional language. It says that the applicant, the property owner, after considering all that, it may be eliminated or reduced by the administrative official. So that's a standalone provision, which, as he's pointed out, could have been meant to be part of the site plan review, but as it stands outside of here, doesn't mean that the Planning and Zoning Commission can't, under its whole standalone clause of and provision of conditional use, do the whole thing. What happened in the prior case is that they chose not to. They chose to say, okay, and you can look in the minutes, they had questions, they did this, so okay, we're gonna make it a condition of approval. And then you go to we're gonna opt out of that particular finding. But they don't have to make that a conditional approval if the Planning and Zoning Commission wants to exercise its full authority under C. There's no reason to have to go there. So I just want you to consider that interpretation also.
Yeah, but I remember, so really the substantive error here was that they referred to the administrative waiver at all. If they had simply referred
Right.
to C and had just made one motion instead of two motions,
There
you
would-
see,
there
it
would
would
not
be
be
all
an issue
over.
then.
There wouldn't be an issue. And then the question is, what would they have done with the fault zone issue, you see? Because it would have been the main motion, do we approve the conditional use, yes, no? You see. And at that point, they would have had to say, yeah, and by approving this, also, by the way, we are waiving the fault zone issue.
They
You
would have
see.
had to make findings in support of
Exactly,
that. That's right.
exactly, but they didn't do that here, you see,
But-
that's the problem.
But they do have a duty and responsibility to consider 8 factors here. That first factor is height. It's the first factor, I mean. And we can fault all.
But they
the-
did. When you look at the
That's-
transcript, they talk
That's
about
exactly
this
my point.
in
is
many
that
cases.
there's
And so the
probably
implication
20
is-
pages of that.
Right.
And so the implication, if I may, is
Yeah.
that they did that.
Exactly, and
And
the
so-
implication is that they approved it because they considered it.
Right. They
You see.
considered it, and in order to do that, they had to have waived that.
Exactly, exactly. So they got themselves wrapped around the axle by then referring to the administrative waiver situation separately.
And and I am still absolutely befuddled that the boats didn't track exactly the same.
Well-
I cannot.
Well, we
Grasp
can
that concept.
speculate what happened.
Well, we can,
There's
but-
nothing in the record to support any of those speculations, so I don't think we should engage in speculation.
It would be.
All right, any further discussion regarding the motion, the pending motion?
No, I intend on supporting.
Okay. Mr. Adams, any further discussion?
No, I would be
Okay.
supporting.
Madam Clerk?
Baragucho,
Yes?
Robert Stewart,
Yes.
Dwayne Adams,
Yes.
The motion passes 3-0. So having now concluded that there was a mistake of law that the Planning and Zoning Commission made. The question, of course, is where do we go from there? And that then immediately leads to consideration of the next issue, and that is what's the remedy here? Remember what I said initially, this board has the authority under 213100 to either remand a case under certain conditions or to correct it by reversing or modifying the Planning and Zoning Commission decision. Those are two distinctly different remedies, and so in order to flesh this out, I would entertain, and we need to address those two remedies separately. I will entertain a motion that that case 2014-0119, that's the Planning and Zoning Commission case, should be remanded to the Planning and Zoning Commission for full rehearing after notice. Anybody willing to make that motion?
What was the last part of that, for full?
Should be remanded to the commission for full rehearing after notice of issue number 2, and that is the administrative waiver.
I'll make that motion, but I necessarily won't be supporting, or at least
Okay, I understand.
I'll make it to just get it on the record.
Okay, thank you. Mr. Adams, will you be seconding this, or
I'll
should
be
I?
seconding that.
Okay, all right, it's been moved and seconded. That is a remedy for the substantive error that we've determined P&Z committed. The case should be remanded to P&Z for full rehearing after notice of issue number 2, and issue number 2 is the administrative waiver under 2145-265A16C. Okay, Mr. Stewart.
Okay, I don't believe in this case that it's the best way to solve this particular issue, because I think we've got the ability to make a final decision rather than having it go back to the Planning and Zoning and then back up again. Because I think there is a way to correct the Planning and Zoning resolution rather than sending it back to rehearing, which I think would allow us to finally dispose of the matter rather than putting it back into lengthy hearing and more review limbo.
Okay. Mr. Stewart. Mr. Adams, I'm sorry.
I think secondly, to remand it back to the Planning and Zoning Commission, who doesn't have authority over the issue anyway, subverts our previous motion. We cannot remand something to a Planning and Zoning Commission for a rehearing on a matter for which they have no authority. So as a result of that, that motion simply has to fail by its own weight.
Okay. Let me just add my 5 cents worth. Under 213100, we may remand a case to the Planning and Zoning Commission only under 2 conditions, in 2 circumstances. 1, if there's insufficient evidence for a decision, or 2, if there was substantial procedural error. Mistake of law does not fall under either category, and we have other alternative remedies here available. So for that reason, and of course, Mr. Adams is quite correct. How can we send something back to the Planning and Zoning Commission when we have already determined they didn't have the authority to make that decision? So it is for that reason that I intend to vote against the motion. Any further discussion? Seeing none, please vote. The findings of fact will be those of Mr. Stewart, Mr. Adams, and myself. Madam Clerk?
Karen Cuccio,
Nope.
Robert Stewart,
No.
Dwayne Adams.
No.
And the motion fails by a vote of 0 to 3.
Mr. Chair?
Ms. Tucker?
In prior decisions, when the board comes back to look at them, I have reflected that the board declines to remand for these findings. And you have indicated that you would prefer that to be phrased differently. How would you like this motion to be phrased so that it doesn't come across as a double negative?
Okay. Let me see if I can do this here. Well, why don't we simply say, case 2014-0119 should not be remanded to the Planning and Zoning Commission for full rehearing after notice regarding issue number 2.
And then you want the vote to be
In the positive
You
as
might wanna
opposed to,
move.
so, first of all, I believe Mr. Stewart made the motion, and Mr. Adams seconded that, so, Mr. Stewart, are you agreeable to simply rewording the motion so that, and we will re-vote on it, but the outcome presumably is the same, except we will then have it
Well,
worded
yeah,
in a
one's
positive
negative and one's
manner as
positive.
opposed to a negative manner.
I will so move.
Okay, Mr. Adams, is that okay with you?
That's acceptable.
All right. Any further discussion regarding the motion? So we are essentially redoing the motion on the issue by rewording it. It is the same, substantively the same motion, it just simply has been reworded. So having said all that, again, the findings of fact will be those of Mr. Stewart, Mr. Adams, and myself, and we will now vote. Madam Clerk?
Karen Cuccio,
Yes?
Robert Stewart,
Yes.
Dwayne Adams.
Yes.
Thank you for bringing that to my attention, Ms. Tucker. Okay, moving right along. So now having declined to send the matter back, the question is, what do we do? And remember what I said before, in support of the motion that we have alternative remedies that this board can exercise. We can either remand it, which we have just declined to do. We can then either reverse or modify the Planning and Zoning Commission decision. So then,
I would want the board to consider that in other decisions that the board has made, that did not remand, but then use one of those alternatives, that at some point there's a preliminary finding by the board that there is substantial evidence on the record on factual issues or on whatever issues you're going to decide, to go ahead and substitute your judgment if it's not just on questions of law.
well, I think that will come up as we are considering the remedies that are available, because the next one is, remember, we need to break it down further. Are we going to reverse the decision, or are we simply modifying it? And I think your thought is appropriate at a slightly later stage. Okay?
Just as long as.
No, I understand. We will keep that in mind, and please remind me again if I overlook this a little bit later. Okay, so as I said, the next alternative remedy this board has is to reverse the decision of the Planning and Zoning Commission regarding issue number 2, and I will simply make the motion, and it is the Planning and Zoning Commission decision in case 2014-0119 should be reversed. Is there a second for that motion?
Second.
Thank you. It's been moved and seconded, and I will speak to my motion. I intend, yes.
As looked at before, when you're talking about the decision, you were talking about their decision on the fall zone as
Correct.
administrative.
Second issue,
waiver.
second issue only.
Thank
We're,
you.
as we've mentioned before, the first decision has not been appealed and stands. And the first decision is the conditional use decision that the Planning and Zoning Commission made. So we are not discussing that decision by itself, although we will, in all likelihood, later on have to tinker with the resolution that was passed, okay? Okay. As I said, I made the motion that we simply reverse the decision of the Planning and Zoning Commission regarding issue number 2. And I intend to vote against that motion. You cannot reverse a decision where the issue was taken up in error. I mean, it can't be done. Here, the Planning and Zoning Commission erroneously believed it had the authority to make to rule on the fall zone waiver. We have determined that it does not have that authority. A reversal would mean granting the fall zone waiver, but we have already determined that P&Z had no authority to rule on that it is under the circumstances of the case and under the posture of the case, it is really the administrative official who has to make that determination if he so chooses. And so consequently, simply reversing the Planning and Zoning Commission decision on that issue, on issue number 2, on the fall zone issue, simply does not. It is not workable. It can't be done. And it is for that reason that I intend to vote against it. Now, Ms. Tucker is going to say you should not be voting on something in opposition, but I must tell you, I think I disagree on this one, because it should be obvious that having decided, no, we are not going to reverse the decision, that the only other alternative we have then is that we modify the decision, and that obviously will be really where the meat of this matter rests later on. Yes?
My concern, as that you were teasing me about, is the same as in the prior one, and it's really a drafting issue that comes to me. If the chair is happy with me recording this in the decision as declining to reverse the decision, then I'm a happy camper.
Okay.
But if, as with all the other times that I have done that, you have indicated that you would rather have it be shown as a
Well-
positive, then you'll need to restate the motion
Well-
either here or at the decision setting in a more positive way, or accept, decline to reverse the decision.
Okay, well, you got me there, and so I will simply restate the motion. And it should then read as follows: the Planning and Zoning decision on issue number 2, that is the fall zone issue in case 2014-0019, should not be reversed. And Mr. Adams, I think you were, no, it was Mr. Stewart. Thank you.
Second.
Okay. All right. Any further discussion regarding that? If not, have we had full discussion on this? Is there any further discussion that we wish to have on the motion?
It's basically irreconcilable.
Yep. Great. Mr.
It's a
Adams?
simple matter of law. It has nothing to do
Yeah.
with anything more than that.
Okay, so please vote. The findings of fact on this issue will be those of myself, Mr. Stewart, and Mr. Adams. Madam Clerk?
Mayor Guccio,
Yes,
Robert Stewart,
Yes.
Dwayne Adams,
Yes.
the motion passes 3-0. All right, so that leaves us then with the remedy of modifying the decision. And I should, before we make that motion, I should tell you that I agree with a statement, with a general statement that was made by Mr. Stewart earlier, that it is far preferable for us to modify decisions to expedite things, because otherwise it goes back and forth between this board and the Planning and Zoning Commission. And so in the light of that, I will entertain a motion to be voted on either up or down in the positive, perhaps, that the Planning and Zoning Commission decision in case 2014-0119 as to issue number 2 should be modified to correct the Planning and Zoning Commission's error of law. And I'm waiting for a second of that motion.
Second.
And it's been moved and seconded. Let me just make some notes here. All right, we have already agreed that the Planning and Zoning Commission decision regarding the conditional use was proper, and the record is replete. After you've read the transcript, you come away with the firm conviction that the Planning and Zoning Commission considered first of all, the general conditional use standards as contained in, hopefully what section is this? Anyway, and the special planning and zoning conditional use provisions regarding the tower. There was significant discussion, thank you, and I'm looking at the general conditional use standards under 2150, is it 080 or 100? I cannot remember off the top of my head. Anyway, it is 2150 or 20.
Right.
2150 or 20. The record is replete that they considered all those standards that are contained in that section, that they also considered the special conditional use standards relating to towers in 2150-280, and that they also considered at length the supplemental district regulations for towers, except that they misapplied that one section that we've been talking about. So I must tell you that I feel comfortable saying that that decision was proper and does not need to be tinkered with. However, what needs to be modified clearly is the second motion. That concerns the fall zone issue. The first issue was not appealed. It's supported by the record. It was not appealed or questioned by any party to the appeal. I think the decision of the fall zone waiver was an error, and it should simply be deleted, and we should exercise our authority to delete that from the record. The findings of fact of resolution 2014-058 should be amended. And so it is that I will vote in favor of my own motion. Further discussion by Mr. Adams, who seconded my motion.
I think also to reflect the language in 280C as well, the language specifically says P&Z may waive or reduce the burden on the applicant by one or more of these criteria if P&Z concludes that the goals of the ordinance are better served thereby. As you mentioned, it's replete. There's probably 20 pages that deal with the height issue. There's no doubt that they concern that, and by making a motion and approving, they had to have reconciled these matters. And as a result, certainly the conditional use stands. And thus it obviates that there is not a need for the second matter.
Okay. Mr. Stewart, any thoughts on the matter?
I agree that the conditional use issue was adequately aired and lots of discussion, and that they in fact considered all their issues and all the standards. So I'm going to vote in favor of that.
The only additional comment I have is this. As I read the transcript, it was clear how they arrived at the decision on the first issue. That's the conditional use. And then the second issue and the vote on that came just totally out of the blue. There was virtually no discussion. And it is really contradictory. It makes you wonder what in the world was going through their heads. Why in the world did they approve the conditional use in the first place if they had some question about the waiver of the fall zone issue? Did they, we can speculate what it is, but there's clearly nothing in the record that justifies that decision. And so I think it needs to be struck, and we need to deal with that issue on our own.
Well,
And it is.
and
Yes.
there was confusion in the transcript for them dealing with that as to why they were doing it and what was the impact.
That's true.
There was confusion.
Yes, yes. And that was discussed while they were talking about the conditional use, not regarding the second issue. You see, that's the interesting part of it. Okay, any further discussion regarding the motion? And the motion again was that we modify the decision of the Planning and Zoning Commission case by deleting. Case should be modified to correct the Planning and Zoning Commission error of law. That is the motion. We ready to vote? If so, the motion, we should vote on the motion, and the findings of that will be those of myself, Mr. Adams, and Mr. Stewart.
Baron Gutschall,
Yes,
Robert Stewart,
Yes.
Dwayne Adams.
Yes.
and the motion passes 3-0. All right. So having decided to delete that, then the question is, what do we do with the rump of the resolution that was passed by the Planning and Zoning Commission? And as we have done in numerous occasions in the past, I think we need to simply start rewording the resolution, and in so doing, we are exercising our independent judgment that we are authorized to utilize. And I need to get my fingers on the original, and I would all of you like to get your fingers on the original resolution.
It's in this document, Baron.
It is in there somewhere.
Number
And if you
2,
would open that, I
just
would
in front of the map.
appreciate it. I have copied it off myself here for greater use and ease. Ms. Tucker.
Do I understand that the board, what I'd like the board to consider is that if they are going to substitute their judgment for that of the Planning and Zoning Commission, that they do a formal motion
Okay.
to substitute their.
All right, okay. I will then entertain a motion that this board exercise its independent judgment to modify the decision of the Planning and Zoning Commission in case, in the planning and zoning case 2014-0119.
So move.
It's been moved and,
And I think do we need to reference the resolution as well, 2014?
yes, I think it would be good to refer to resolution 2014-058. Mr. Stewart, will you be seconding
Yeah, that change?
No change,
Or
just.
that?
addition.
No, that we
Resolution.
substitute our independent judgment.
Oh, yeah. Okay, I second that.
Mr. Adams?
We found in our previous actions tonight that the Planning and Zoning Commission cannot sit as the administrative official. The language in Resolution 2014-058 specifically states, whereas the Planning and Zoning Commission was acting as the administrative official through their role in reviewing and deciding conditional use, that language cannot move forward because they don't have the authority to do that. So that needs to be amended, and any supporting narrative or any narrative that builds on that has to be stricken. And so we do need to take action to resolve that.
And we do that by exercising our own independent judgment, correct?
Thank you.
Mr. Stewart, anything further?
I have nothing further.
Okay, I have nothing further. If there's no further discussion, we are ready to vote, and the motion will be based on the findings of fact of Mr. Adams. Are we ready to vote? Madam Clerk?
Mayor Guccio,
Yes?
Robert Stewart,
Yes.
Dwayne Adams.
Here, yes.
Okay, and the motion passes 3-0. All right, now we get into the substantive changes that we want to make. And probably, if we simply go around and we come up with changes, and I propose to call first on, I don't care, I could go first if you want me to, so that gives you a little bit of time. And regarding, once we have a small number of proposed changes, that we simply vote those up or down.
Okay, so are we going to do something like we did in the prior one and just refer to the attachment for the changes?
To the attachment.
In other words, on the motion?
The former resolution?
Amend the motion to say that we're going to see the attachment for changes?
Yes, that will be contained in the conclusions of law later on.
Okay.
Okay? So we simply refer now to Resolution 2014-058. And do you want to go first and propose some changes to it? Mr. Stewart? Or do you want me to go ahead?
I would rather you go ahead,
Okay.
because I've got a couple of things I need to add towards the end.
Okay, all right. If we look at page 10 of our lawyer's memorandum, let's see, I don't want to get myself wrapped around the axle here. Yeah, there were some suggestions made by our counsel how, what we should say first by way of starting this out. And so I propose, if you look at page 10 of her memorandum and simultaneously look at the resolution, that we strike the third recital clause, not recycle, but the third whereas, the plan, and simply strike the third whereas. And that one was, whereas the Planning and Zoning Commission was acting as the administrative official through their role in reviewing and deciding on the conditional uses. So that's the first one to strike. The second one is to strike all but the first sentence of paragraph B and retaining only, the commission passed the motion to approve the conditional use by a vote of 6 ayes and 2 nays. And the third that we can immediately do is that we strike the word denied and substitute the word heard, so that the sentence would state, heard by the Anchorage Planning and Zoning Commission on the 13th day of October 2014, and that is 2/3 down on page 2, following B of the proposal, of the decision. So those are the initial 3 changes that I have in mind, and I will move that they be incorporated.
So moved.
And,
You want a second?
well, you will second that because I moved that.
Oh,
I moved
you
it.
moved
I
that. Oh, I'm-
misspoke.
okay.
I'm so sorry.
I second them.
Okay?
That takes care of the first 3.
I think it follows logically that these changes should be made. We are striking any reference to the Planning and Zoning Commission acting as the administrative official. That's the first one. The second one is that we strike in paragraph B everything except the commission passed the motion to approve the conditional use by vote of 6 ayes and 2 nays. And the third one is that we strike the word denied in the following paragraph and simply say heard. And Mr. Stewart, you seconded my motion. I tell you, to my way of thinking, that is a good introduction to start with the changes that we need to make to this motion, and I'm in favor of it, and I intend to vote for it. Mr. Stewart.
Nothing to add.
Okay. Mr. Adams.
Nothing to add. I would just say this brings us in line with the rest of our determinations tonight.
Yes. Okay. I have no further comments. Please vote. The findings of fact will be those of myself and Mr. Adams. Madam Clerk?
Mayor Kuchar,
Yes.
Robert Stewart,
Yes.
Dwayne Adams.
Yes.
And the motion passes, and the changes should be noted. Ms. Tucker, did you get them?
Yes, I did.
If not, you and I can get together
Yes, I got
afterwards.
them. I got
Okay.
them.
All right. Further changes to the findings, to the decision of the Planning and Zoning Commission.
I've got a couple.
Okay?
Two. I'm wondering if we should, and I'm just throw this out for some little discussion about 3C, where it says the petitioner did not gain support of the community council. And in reality, it was more of a negative rather than a positive, because it was a vote. The motion was to oppose the conditional use, which failed by a vote of
Yes.
10 to 18. So is that something from a substantive nature that we need to look at, or do you think that?
I think we need to do that by way of providing guidance to the administrative official who is to make a decision on this issue. Yes. And so I think that does need to be changed. And I must tell you, when I looked at that, the way I changed that was that I referred to the fact that it was that the motion to oppose failed. That the motion that the motion by the community council meeting to oppose the proposed conditional use failed by a vote of 10 to 18. Because that's apparently what happened. Does that make sense?
Yes, or I was thinking, well, much the same thing.
If you have
Just-
better wording, that's fine. I'm not.
No, mine was just almost a little bit more innocuous. The community council voted against opposing the pole extension.
Okay. That's fine. Anything else? Do you want to?
There are a couple other things. In the record, the planning and zoning did include the following conditions on the conditional use, and they did not add them to their resolution. One was, in the event the power line is undergrounded, the cell tower approval shall be considered void, and that's in the transcript at page 92 and 95.
Mm-hmm.
And then there's a second one, that the construction will be in accordance with the site plan on page 95 of the packet provided Planning and Zoning Commission, and accompanying technical drawings to include sheet number E1, sheet number E-102, and sheet number E2. And that's in the transcript at 95 and 96. Plus, a third one is the communications equipment box will be painted to match the church. And that's in transcript at 95 and 96. So
Okay,
those,
well, let me, I agree with you regarding conditions 1 and 3. I do not agree regarding number 2, and the reason is that it is a standard provision in conditions to say, as was done in the prior case, 2010-033,
Mhm.
that the approval is subject to all conditional use standards in accordance with 2150-280, 2150-20, the general conditional use standards, 020, 2145-265, the supplemental district standards regarding transmission towers, comma, the petitioner's application, comma, narrative and submittals, comma, except as modified by these conditions of approval.
okay, that
And
captures
that's
what I
the
was after,
standard
too.
language that appears in all conditional use cases, and so I would like you to substitute that for it,
Okay,
as opposed to referring to the specific pages in case those page numbers were in error or what have you. It simply incorporates all the presentations by the applicant. Okay?
yeah, that's more inclusive than
Yes.
this.
Yes. And I take it you are making this by motion,
Yes.
okay? And I will be seconding that. So, Mr. Stewart, speak to your motion, please.
Well, I think what this does is it clarifies exactly what the planning and zoning did, and that was omitted from this, from their resolution. I think this corrects that oversight.
Okay. All right, I agree, I intend to vote for the motion. I think the reason that that the conditions number 1 and 3, that is the overhead electricity wires, when the overhead electricity wires are removed, the conditional use shall be void, and the painting of the box, that the reason those items were not added was because in the end the whole thing failed anyway as far as P&Z was concerned and as far as staff was concerned, when you look at the transcript, you know that these were specific amendments that were voted on and approved by the Planning and Zoning Commission, and that's why they need to appear, and they were approved as conditions of approval. So they need to appear in our reworked decision. Okay, and it is for that reason that I intend to vote for it.
And I have
Mr.
nothing-
Stewart?
I have nothing to add.
Okay, are we ready to vote? If so, the motion will be supported by the findings of Mr. Stewart and myself. Please vote.
Baron Gutschall,
Yes?
Robert Stewart,
Yes.
Dwayne Adams,
Yes.
All right, further amendments.
May I suggest something?
Of course,
We can
of
discuss
course.
that. 2 paragraphs, and let me hear out both.
Yes.
Inserting in the whereas language, whereas the Planning and Zoning Commission heard a motion for waiver of antenna height, but such hearing was determined to not reside within the authority of Planning and Zoning Commission. And whereas the review of antenna height was considered as part of the conditional use decision, as were other factors in accordance with 2150-280C.
Okay, so you want to add that as a whereas?
In the whereas language.
Okay, as a separate whereas?
2 separate whereas clauses.
Okay, all right.
I need to back up for just a second to clarify the record on the former motion, if you don't mind, sir.
Okay. The previous one?
The previous one.
Okay.
And what I'd like to make sure that I understood correctly is that there was actually 4 conditions, even though you talked about 3. That the first one was mentioned and included in that vote, which was that the community council voted against appropriating the pole extension. So I
You
know
are
there's
so
going to be
right.
confusion on the record. I understood that you grouped the other 3 together, but I want to make sure, and you talked about them as 1, 2, and 3, but they were B, 1, 2, and 3, and the A one that was included in there was community council. Do I have that right?
You have that right.
Okay, so as long as that's correct, then I don't think you have to go back and do anything. I just
Yeah, yeah.
wanted it on the record, so
Yes,
that when
yes,
I
yes.
do the decision,
Yes.
that my decision will comport with what you
Okay,
intended me to
so in
do.
other words, 3B needs to be amended not only to say it did not gain the support of the community council, but the community council didn't oppose it either.
Yeah, that was
Because that's really
That's
what
the first.
happened. It did not, remember, the motion to oppose it
Right.
failed.
Right.
So you need to make sure that when you reword 3C, that you add that in.
Right, because
The
that
petitioner-
was, you included that in the
Right,
first motion.
3C
So I
needed to
wrote
be
that down.
changed.
You
Yes.
changed, and then 3 other conditions.
And then.
Correct.
And when you were talking about those 3 other conditions, you did 1, 2, and 3, but the first condition, so included in that
yes.
motion was on the community council.
That's
As long
correct.
as we're okay.
Yes, yes.
Then you'll get to see it in a draft decision anyway.
Good, okay. And now,
Now-
Mr. Adams wants to add 2 whereases. And
Right.
you don't have those yet, so, Mr. Adams, you need to repeat those so that our trustee council can jot those down.
Whereas the Planning and Zoning Commission heard a motion for waiver of antenna height, but such hearing was determined to not reside within the authority of the Planning and Zoning Commission.
Okay, so whereas the P and Z heard a motion,
I guess we perhaps could say conducted a hearing. I'm not sure
okay.
which is best.
Conducted a hearing, let's try that. Conducted a hearing,
For waiver of antenna height.
the waiver of intent, right, okay.
But such hearing was not determined to reside within the authority of Planning and Zoning Commission.
It wasn't antenna height. Remember, it's the
Proximity.
proximity.
I'm sorry,
It's
you're
the
you're
fall zone.
exactly right.
The
The
fall
fall
zone
zone.
issue.
It incorporates the height in
It
that.
is
Right,
part of
but
the
it's the
proximity.
fall
It's
zone
the
issue.
geometry, fall zone.
The separation.
separation. Thank you.
Okay, but such issue was determined,
And whereas, right, to not reside within the authority of the Planning and Zoning Commission. And then the second whereas would be, whereas a review of tenant height and separation distance, I would add, was considered as part of the conditional use decision.
okay, I guess, I'm wondering, the review of antenna height, and are you really talking about the antenna height this time?
Well, it's,
Or the
the height
fall
is a
zone.
function of the separation distance, so the height in its separation distance, because it's the 200%.
The
Of the height.
separation,
The fall zone.
separation distance
Right.
from adjacent property.
Fall zone
Uh-huh.
was considered as part of the conditional use decision, as were other factors in accordance with 2150-280C. There's no discussion whatsoever that there should be reference to 2050-280C regardless.
So whereas review of that fall zone, height and separation distance was considered as part of the decision, but what?
I said the conditional use decision.
Part of the conditional use decision. Uh-huh.
As were other factors in accordance with 2150-280C. I can speak to what I'm trying to do
Well,
here.
just a
We
second.
can modify
She
that.
needs to jot this down
Yeah,
first.
when we get there.
And then we get there.
Okay.
That's your whereas, the second whereas?
Yes.
Okay, and that's your motion?
With a reference to 2150-280C.
Got it?
Okay,
Okay.
yes, that is.
And that's your motion?
That is.
Okay. And I will second that just for discussion purposes.
Okay, so, we need some language. There's a lot of effort being expended now. There was a lot of effort expended by staff and the commission in discussing this and understanding that needs to be reflected in here is my first thought. And number two, we need to reflect why we're making the decision we're making now, which is that they did consider this. Those are the 2 points. And so that's the language.
Okay, so just.
Okay, just,
Go ahead.
all right. My thought is this, that in accordance with prior practice, I want the conditional use that was approved to be conditioned upon the planning administrative, the administrative official waiving the fall zone issue.
So he she needs.
Correct. What you are doing with the second whereas, you're doing away with that.
Well,
And I don't think I want to go there, I must tell you. You understand what I'm saying? I
Right.
want as a separate condition of approval that that the administrative official, whatever he's called, needs to grant a waiver of the fall zone issue.
right, and I don't disagree with that. I don't think we're there yet. We aren't done crafting the motion, right?
That's correct.
So I assume that we're going to.
I see. What you're saying is by putting that whereas, you're simply saying they considered it, but they didn't rule on it.
Correct. And it provides direction to the administrative official that they considered that. And I think that's a very important.
I think that's true. Okay.
So that's all I'm saying. That's all we're
Okay.
dealing with. It's very compartmentalized.
Okay.
Wait.
Ms. Tucker.
And I would ask that the board consider, instead of making those things whereases in adjusting this decision, to make those actual findings
Oh, okay.
of the Board of Adjustment, instead of trying to make them as recitals in a prior decision of P and Z.
Okay.
Okay,
I think-
and where that can fit in is if we look at our prior motions. We
Mr.
can-
Chair?
Yes.
One of the things that you asked me to do is look at, and I just offer this as an alternative, as something for the board to consider, to look at some other decisions, and we haven't had a discussion about that, but sometimes in other decisions, or at least in one other that I found, there is a place to make findings, so that you have your conclusions and your findings, and then the Board of Adjustment has said, in keeping with the above, and here's some other ones. And so, that, you know, there's.
Okay, so so it's a standalone finding, really, that's what you're saying?
Right. I don't
Okay.
think you necessarily have to fit it in yet.
Okay,
To
that's
something
fine.
else, I think they're good findings.
Yeah, okay, so what Ms. Tucker is suggesting, that what you labeled a second whereas, that it simply be done as a separate finding.
Well, for both of them.
For both of them, so this would be
Yeah.
number 4 and number 5, or whatever numbers we're at.
Right, if we
Yeah,
have some other things in
exactly.
there, then we have in consideration of all the above, kaboom.
Yes, okay. I think that's okay with me. Mr. Stewart, any discussion?
No, I'd rather see them as findings, but I'm a little concerned that the way we've got that first one,
Try again the first one. Read,
it
Right,
bothers
Ms.
me.
Tucker,
that is
read the
correct.
first one
Okay, so
again.
I have, well, it's easier for him to read it since he wrote it, but he can correct me, whereas the Planning and Zoning Commission
Held a hearing.
it held a hearing, yes. Or I had considered in hearing a waiver of
Separation
separation of that fall zone, but,
criteria.
well, you go ahead and read
What-
it. because-
So,
We're talking about the first whereas, and leave off
Right.
whereas because we're making this a
Right.
finding.
the Planning and Zoning Commission conducted a hearing for waiver of separation fall zone criteria, whatever that language is in the code. But such hearing was determined not to reside within the authority of Planning and Zoning Commission. That's what it says, and that probably could be wordsmithed better.
I must tell you, that's duplicative of what we've said before, because we've already had a motion that passed that said they were
In error.
outside, they were in
Okay.
error. So I think that would be duplicative.
Okay, if,
You know, what I was concerned there was the use of the word waiver, and waiver is used in 215280C.
yes, it is.
But it is also contained in 265 A16C.
So it, you know.
So,
right.
It's used in both.
So the nexus is it the intent of the drafter of this,
Exactly.
assuming it all happened at the same time, which I don't believe it did, that waiver is the same thing. But that raises the whole specter of whether that language in 265 actually pertains to the site plan hearing, not to any independent action by the administrative official. But we can't make that determination.
Okay.
It's a larger issue.
Yeah, in 265 16C, it's not really saying there's a waiver, but there's power that is to reduce or eliminate.
Right.
Right, so,
The separation
the
distance.
reason why it's difficult here, I think, is what you were getting at, sort of about that first whereas, is that because the Planning and Zoning Commission was, at least this is my understanding of where this board is at, that because the Planning and Zoning Commission was erroneously told that this other thing had to be made, that an inference from that is that they then assumed after the fact that they didn't have the authority to do what they had just done in whole to grant the conditional use, and so that this board has a hard time substituting its judgment for that of planning and
Right.
zoning to go ahead and do it. If it was a clean hearing and planning and zoning hadn't been instructed that way, then the granting of the conditional use would have by its
I
nature
understand.
covered that. Is
Exactly.
that where you guys are at?
Yeah.
Yeah.
Yeah. And that needs to be, you need to flesh that out a little bit. But that's basically what we're saying. Okay, so where does that leave you?
So-
The second whereas, no, was it the first or the second
The
we're going to
first-
delete?
The first whereas, my first whereas, which we suggest to be findings, I withdraw,
Okay, good. That then
That-
leaves
that
just the
clarifies,
second
yeah.
one.
which leaves a second, which is.
Would you repeat that, please?
The review of separation height was considered as part of the conditional use decision, as were other factors in accordance with 2150-280C. So
Okay.
where I was trying to get in, and this gets to Ms. Tucker's argument, is if the thought was, well, we're going to consider 7 of the 8, but not the 8th, because that's going to be considered in a separate motion, well, that's a whole different thing.
Okay.
And my suggestion, the way I look at this, is if you grant the conditional use, you de facto are, you have a
Except-
duty and responsibility to consider 8, not 7 of
Exactly.
the 8 or 4 of the 8, in the hopes that something else. It
Yeah.
doesn't matter that then the second, the waiver, or whatever you want to call it, the reduction, is a perfunctory
That's
task. And I
true,
believe
except
that that's
for-
probably what staff thought would happen.
Except for the tension with 265 A16C.
Right.
You see, that's the problem. So we somehow need to bring this out. If they had followed simply one procedure, it would have gone by the wayside. But since they didn't follow that procedure, the applicant still, as a condition of approval, needs to get the administrative waiver.
Right.
Okay.
So let
And-
me just, for council, when motions are made and a body here or in the Superior Court makes a decision, each must stand alone, shouldn't it?
Absolutely, yes.
So if they each must stand alone, how does that change this then? I mean, you have to assume that they considered all 8,
Well, we've already said that.
right?
We've already said that.
So,
That
how
that
do
they
you feel about
considered,
this?
no, that they considered all 7 with the exception of the height issue, the fault zone issue,
Okay,
which they deferred, you see. We have already said that. Where did I come up with that? I said,
right, we've said, okay, the 7 of the 8,
yes,
but
we said this approval is subject to all the conditional use standards in accordance with 2150-280, 2150-020, and 2145, 265A, except for A16C, or whichever way around it is. Okay, we've already said that. Okay, so we've got that in there already. Oh, yes, that was part of my earlier motion. I can assure you. This approval is subject to all conditional use standards in accordance with 2150-280, 2150-020, or was it? Yeah, 2150-020, and 2145-265, except for,
Wait, and I must have misunderstood that, because I thought you were using that decision and saying except as modified herein to cover something else that Mr. Stewart was
okay, that's a
saying.
possibility. We
And
need to
so-
tinker with it when we see it. We're getting, I think we are all talking about the same thing. We just need to put it in proper language later on. Okay, so where does that leave you? Why don't we tentatively
Well-
say, your proposed amendment stands as a separate finding of fact. And we will simply look at it to make sure it's not repetitive later on when we have the whole package in front of us.
Okay.
Okay, does that make sense?
Mm-hmm.
Mr. Stewart, does that agree with you?
Yes, because I'm not sure that we actually need that in
I'm
comparison to
not
what we've
either,
already got.
because I think we will find that this has already been addressed when we're all said and done.
Yeah, I mean, it turns on the issue of whether in considering the conditional use, they considered that fall zone.
Yeah,
Yes.
I understand what you're trying to do, and I'm not sure if this is going to clarify it or it's just going to. We need to see it in context.
Yeah, I mean, I'd like to hear your thoughts of whether
I-
that's a standalone. I mean, do you feel that the approval of the conditional use only considered 7
Yes, most
issues
of,
and not the 8?
well, they discussed it, but they,
At length. They
At
did not
length.
discuss it at
They-
all in the findings.
but they somehow wrapped themselves around the axle, but then separately considering it subsequently, you see, and denying it. It appears to me that they first approved it and then they denied it. That's really what they did.
Well, yeah, in effect, that's
Yeah.
exactly what they did.
That's exactly what they did. And so, in order for us to fix it, we will simply say they applied all the conditional uses under the two statutes, under the two ordinances, except for the fall zone issue. You see,
I think the remedy that we're providing in the end is going to take care of it. So
It will take care
We'll
of it.
probably be the enforcement.
okay, all right. Further changes, Mr. Stewart. Do you have anything?
On his,
So
are
have
you
we-
gonna take
There
a
you go.
vote on his?
So have we withdrawn, are you asking
Yes,
that I
yes.
withdraw both?
I'm asking that you withdraw.
Okay, let's withdraw both and the second agrees.
Okay,
So,
yes.
And then on, just because I'm gonna be drafting it, let's assume for purposes of
Yeah, yes.
caution that there hasn't been a vote on this business about that they assumed
Yeah,
7
Well-
versus 8, and also keeping in mind what you said about not speculating, then do we just reserve that issue
Yes.
until after you see the whole
Correct.
thing? Okay,
Yes.
thank you.
yes. That's the intention of what we want to do. All right, Mr. Stewart, do you have something, or do you want to check your voluminous notes, and I can do something in the meantime here?
No, I think I've hit the items that I was looking at.
Okay, well, I have a few more, and that is, I'm looking at the staff analysis on this particular case, 2014-0119, and I'm looking specifically at pages 10 and 11 of the staff analysis, which is pages 16 and 17 of the record. And it contains the standard conditions of approval, and I want to be sure that the decision is modified by us contains the standard conditions of approval. So if you look at page 16 of the record, you will find that on the bottom there, A1, it says, the department recommends approval of conditional use subject to the following conditions, okay? And so I want to be sure that the decision as modified by us contains condition number 1. This conditional use and site plan approval is for a type 1 monopole, local interest tower, cellular or wireless communications not to exceed 79 feet in height, and accessory equipment in the R2M district, in accordance with 215280. Number 2, a notice of zoning action shall be filed with the State of Alaska District Recorder's Office. Proof of such shall be submitted to the Planning and Department. Number 3, this approval is subject, and we had number 3 already, so I'm deleting that. Number 4, tower construction shall be completed 1 year following issuance of a building permit. Number 5, an identification placard shall be attached to the tower structure, etc., as it says there on page 17, condition number 5. that's somewhere in the code, that there needs to be a placard attached, so that needs to be a condition. And then I will add number 6, and number 6 is, this approval is subject to AWN applying for and receiving an administrative waiver for separation from protected land uses by the administrative official pursuant to 2145-265A16C.
Second.
Okay? And
May
it's
I-
been moved and seconded, just one second. I intend to vote for this because I want to be sure that as we make a decision and modify the existing decision, that it is a properly approved conditional use application and follows the standard languages used by the department. And that's why I'm adding these things.
And I
Mr.
agree 100%, and in most resolutions that it has that specific language. The one thing I would suggest is that 3B added, or that our existing language be changed to add in the petitioner's application narrative and submittals except as modified by these conditions of approval, because they could bring something that's slightly different, slightly larger.
We've already discussed that. And
Okay,
that is
did we
already.
take care of that? That was
We
that
took care of
motion.
that.
Okay,
That's why I eliminated it from this.
okay, very good, thank you.
Okay? Mr. Stewart, any discussion regarding these additions, the conditions to the approval?
No, this really doesn't, the way we're doing it, it really doesn't conflict with what I'd originally thought, is that if the whole thing were done under the conditional use, that this is really something that was meant to be considered under the conditional use and included.
Right, I think, and that's the dilemma that the board is faced with, is having gotten this far, do you have enough on the record to to infer that the conditional use included everything and is standalone without further action? Or do you have a conditional use that needs that condition to cover the administrative waivers, and that's up to the board to decide?
Well,
This
go
looks,
ahead.
this looks like what we're doing is treating this is a ministerial act that needs to be completed. Is that the intent?
That's the
Of
intent.
the latter point, and that is the referral to the administrative officer, administrative official, that's basically a perfunctory thing just to
Well-
make sure that we aren't in conflict.
Well, wait a minute. I view it as more
Right,
than a
that's two
perfunctory thing.
questions.
He needs to waive, because
Oh,
remember, the
it
section
is.
specifically says you need to
Well,
take all
yeah,
of these
that's
factors into
poor
consideration.
language.
Right,
I shouldn't
when you
say
say you
perfunctory.
need, when you're saying, I get confused when you say he needs to waive. And where I'm confused is Mr. Stewart's question is it a perfunctory ministerial act which he is required to do, even though the language says may, that he has no real authority not to do it? Or is it something that if he finds that he's not willing to weigh the factors in favor of waiver, that it's
Right.
a condition? And so when you say.
It's a condition, just as it was in the previous case. It's strictly a
Right.
condition.
So the answer is, it is not a perfunctory ministerial act, it's a real condition of approval. And the administrative and the conditional use is subject to obtaining that from, and having the administrative official be willing to exercise authority to grant that waiver under that balancing test that's set out in there for the administrative official to exercise. And if he doesn't, then their conditional use hasn't met that condition.
Correct. Absolutely true. So
Okay,
it's not a
what-
perfunctory act at all.
Okay, and then my point is, where is their due process then? What's their next step?
The next step
have to
is
go to
if a party
Superior
doesn't
Court.
agree with it, in 14H it says, if you don't agree with the decision of the administrative official, you go back to planning and zoning.
I'm not
And
sure
you
that
appeal
that
that.
H
I
applies
think
to
the eight
that, to that,
refers to the site plan review.
right,
No.
and not
Exactly.
to.
No, that's not true.
Okay.
So look at 14H. A decision of the administrative official under the authority set forth in this subsection.
In this subsection,
Which is site selection, site plan review.
I've used
Right.
16C as another subsection.
it's a separate subsection, it's not the same subsection.
No, it doesn't need to be. It simply says, set forth in this subsection.
Okay, that subsection is 14. Initially, I
The
struggled with
appeal.
that
The
because I
appeal.
thought it was referring to subsection A, but it doesn't, because there'd be a conflict with other appeals. In this case, it looks like H applies only to subsection 14.
So then the question is, assuming that the administrative official renders a negative decision, where's the appeal? Because the applicant who then lost must have an appeal possibility.
It looks to me like then the administrative process or due process has been exhausted, they go to Superior Court.
I think to me, it's a
That's
full
not
indication.
logical.
This is in the wrong place. This belonged in 14. It's in the wrong place,
Yep.
to me. I mean,
But
so-
you see, the question is still valid. Where do they go?
Right,
You know, the intention is that if a conditional use is, well, I think the answer is this. If the administrative official renders a negative decision, the conditional use is denied. Okay? So, are you with me so far?
Mm-hmm.
Okay? Well, the appeal from a denial of a conditional use is right here. So they come back. They don't go to Superior Court. Because in that case, the condition, the
Okay.
conditional use failed. And it's
So-
denied. So,
And if that's the case, then it goes back to planning and zoning and then
no,
they
no,
can come back to us.
no. What you're telling me is it does not go to planning and zoning, that the appeal section here in 14H only applies to 14, doesn't apply to 16.
Right.
So if that's the case, then planning and zoning no longer has anything to say. That's done.
well,
Because
this
the
whole thing
decision
is
has been
done.
turned down. The application has been turned down. What's the normal remedy when an application has been turned down? The applicant comes to the Board of Adjustment and says, hey, this should have been granted, not denied.
yeah, but there's time limits on that, so how, I mean,
So let me ask another question. So assuming that this was intended, let's take it at face value as a standalone intended requirement of a petitioner,
Okay,
okay? Where's the process he's supposed to follow?
well,
The petitioner brought that up the appellant brought that up in one of his points, and he's got a good thing. It doesn't say, do you write him a letter, or do you go stand at the planning desk and ask him to fill out a form? Doesn't have to, because there's only two things that really happen here: site plan review, conditional use. This paragraph's in the wrong place. Should have been in 14 because it pertains to site plan review and provides specific direction to the administrative official as to how to address this, because he does not have the benefit of a public hearing. Site plan review doesn't have that. Conditional use process does have that. And so with that, the Planning and Zoning Commission has the ability to waive separation distances. It's vested in their very process, but it's not in the administrative official, so he has this guidance. And it provides that, and he can reduce or eliminate based on his discussions with the community council president and the petitioner and
whatever else, yeah.
whatever else. So it's wrong. So the question to me, there's no doubt whatsoever, this is in the wrong place, but The question to council is, do we have the ability to make that determination? Because clearly, it doesn't say that it is, or that it isn't. So do we, to cover our bases, or whatever, however we want to phrase that, to comply with Title 21, do we have to refer this to the administrative official? And it runs absolutely counter to the fundamental principles of a tiered application and permit process.
So what
Absolutely
you're saying
counter.
is we should simply say, because they approved the conditional use, they inherently approved the waiver of the fall zone.
They have to. It's a duty and responsibility to consider 8 things. And if they said in the back of their minds, well, I'm going to play both sides, we can't ordain that. We can't determine whether that happened or not.
So what you're really saying is 16C really, we disregard it altogether. That's what you're saying.
Well, that's what I'm saying, because it gives the right to waive that specific criteria as well as any other criteria right there in the conditional use. That's what a conditional use is.
Yes, I understand. But we would then totally disregard 16C.
Well, that's the
Right,
question.
what I hear you discussing is that the process in, set out in 16C is consistent with site plan review and is not consistent with conditional use approval, and that the duty and responsibility under conditional use was considered and maintained, and that the secondary process should be severed and disregarded as contrary to code in
Yeah.
your interpretation. And so a more specific question that it seemed that you were asking me as your counsel is whether this body has the authority to do that, to interpret the law, and absolutely. You substitute your
Absolutely
judgment
do.
Okay.
and you
I agree with
interpret,
that.
and if they don't like it, they can appeal it to the Superior Court, and the Superior Court can give you other guidance. But
Okay,
there's
thank you.
deference
So-
to this body with background as yours in trying to make sense of inartfully drafted code.
Okay, thank you.
So really what you are saying, just so that we are all crystal clear on this, the 2150-280C already considered, since they considered all of C of 2150-280, they already waived it. And the fact that they held the second vote was immaterial,
Immaterial.
was really
Immaterial, not
immaterial.
germane.
And
They
in
didn't-
fact, it's inconsistent with their required consideration under 5280C.
Correct.
And
it's
so,
outside the scope of their authority. You've already said in your
Yeah.
preliminary findings. So I don't know about the immaterial and all that. I just think that that what you're saying is that it,
But they fully operate within their authority, and that exercising that authority, they remove the requirement to deal with that. And I think there's circumstantial evidence that clearly indicates there's no, whereas in any other, the plat, a conditional use, a site plan review, an administrative site plan review, any other requirement within Title 21 has very specific application requirements with respect to what has to be filled out, what information has to be provided, the ability of staff to turn that back and say that it's not sufficient. But all of a sudden, here is this outlier that is a standalone administrative review without any process noted, other than 3 people this guy has talked to. But it doesn't say, after having gained the conditional use permit, or having said as part of, or anything, it's an outlier. And I clearly believe that it's simply in the wrong place, that there is circumstantial evidence that clearly indicates that it was simply drafted poorly and placed in the wrong place.
but how do you reconcile that with the 2010 case where they said, same circumstances, a tower was applied for, and they applied the considerations under 2150-020, the general conditional use standards, and 2150-280, the use standards applying to towers. And then they said, we're approving the conditional use, but it is conditioned upon you running to the administrative official and getting the waiver of the fault zone.
I think there's two things that play into this. Is first of all, they saw this same paragraph, go, what in the world are we going to do with this? They just said, well, we'll just say they have to get it afterwards. But they get the conditional use, it's done separately. And then the administrative official kind of has to say, well, I'll follow, I was directed to do so by the commission. I have to comply with what the commission's findings were. However, it's very possible that they may run into this very thing. And so the second thing that suggests that it was problematic because it's in the wrong place is staff said, okay, we'll take care of it at the same time. The same way that a plat that goes to conditional use, if a plat is required, then the Planning and Zoning Commission has the authority and almost always does, that I'm familiar with, and in fact always does with what I'm familiar, acts as the platting authority. They don't necessarily do the best. It's outside of what they usually do, but that's why you do that, so you get rid of that conflict, because you can't have the Planning and Zoning Commission giving an edict with conditions of approval that are controverted by a platting board who, among other things, loads on because they may not have had the benefit of what the Planning and Zoning Commission heard. And so how do you do that? You take care of it all at the same point. And I do believe that the Planning Department, operating in good faith, says they'll go through the conditional use process, and then if they agree and approve the conditional use, then they will grant the waiver. And for one reason or another, it didn't happen here. We wouldn't be here if it had happened the way it was expected to happen, but I think it's all
Exactly.
because of this
That's
problematic thing. And so, my belief, and if we were to add that condition, I would vote no, that I don't accept it, because I think this clearly indicates the height and the distance and all those many factors, all the discussion in here about the building across, and if they were to put in a tower and what the elevation was, it's all stuff that is part of the consideration for the conditional use, the granting of the conditional use. All those things are in there, and they duly considered all of that. And if they tried to play games, if they tried to game the system, then they were operating outside their duties and responsibilities to grant a conditional use. And they should not be gaming the system, because they had a duty and responsibility to consider that very thing.
Yes, there's one other thing to sort of add to that, is that in addition to the site plan review and the conditional use, there is an ministerial permit that's required. And that's the one that is in 265H. And so they have to go, after everything is done, and they have to register. It's a registration permit.
Where is that?
2145, 265H. Administrative permit required. An administrative
Wait a
permit.
minute, I'm looking for it. I
Are
don't see
you
it.
looking for A11?
It's not H.
It's,
There is
did
no
I say
H.
H? I
11.
didn't mean H.
Right, it's 11.
11.
Right.
I
Okay.
meant A11. I misspoke.
Yeah, that's mandatory.
That was that other thing
Administrative
that we
function.
were
Right,
talking about.
and so what I think, so it's very difficult to answer the question that the chair posed about what do you do with that other decision, because we don't have the staff report. We saw how the staff gave guidance to this commission, and we're finding problems
Right.
with that. We don't know how the staff reconciled it in there, and it could be that it was seen as a ministerial perfunctory act somehow associated with this
So-
the age 11, A11.
So you are tying the requirement of 16C into A11? Is that what you're doing?
No, I'm answering
No,
your
no.
question, that you said, how do you reconcile what they did in the prior case that this board has now taken administrative,
Yeah.
has taken official review of, and I'm saying that that would require speculation. But I'm noting, because I had to sort all these out
Yeah.
in there, that there is this other
Requirement,
administrative
yeah.
permit that, and so when it's added as a condition, it just could have been, considered,
we
just
don't
like
know.
this one was. We just don't know. It takes speculation. I mean, I'm just.
But that would reconcile, and that would reconcile those inconsistent requirements. Because then when we say, as part of the permit application that you need to make, you also need to ask for the waiver under 16C, or C16, whatever it is, so that you get it at the same time. That would reconcile those two considerations that are in tension here under large C, 280C, and 265 A16C.
So let me see if I'm understanding this, that the Board of Adjustment is that the Board of Adjustment is somewhat confounded by the
conflict.
placement of,
Yeah.
of
16C.
of 16C, and that either it should have been placed, or it was meant to be placed in the site plan review.
Yes.
But that and to give the administrative official guidance in how to exercise that review, and if not, or in addition, if it's considered at all in the context of a conditional use permit, as opposed to site plan review, then it should be considered ministerial and combined with
Yeah,
11.
with
Is that what
11.
I hear you saying?
Yeah.
Yeah, and so,
And then you're gonna make that, that's gonna be the interpretation, either it was here, and shouldn't be considered at all, or if it's considered, here, if it's gonna play a part in conditional use, then it needs to be
Part of,
seen
yeah.
as,
Ancillary to the administrative permit that's
see
required.
now, the way I read this tells you, for any tower, you walk in the door, I'm gonna build a tower.
mhm.
You have to get an administrative site permit right here. You have to get an
If it
administrative
qualifies.
per- No, you have to. I don't care
Oh,
what
I
kind
see
of a
what you're
tower.
saying. Yeah.
Right, this is sort of
Absolutely.
with
This,
the
this,
context.
Absolutely.
this speaks
There's-
directly to my tier
Mhm,
point.
mhm.
And then if you are in the B1A, B1B watershed, PL, all these,
Mhm.
then you have to go through a site selection, site plan review.
Mhm.
Now, if, on the other hand, 1, 2, 3 within a residential district or PLI shall be subject except when a
conditional use.
conditional use. So we determine whether a conditional use meets certain heights, certain, to the criteria that kicks it up to conditional use, then you're up to that third tier. And at that third tier, you're at the conditional use. So this is just the entry level. This is what you do to get the process started. But that's still, you know,
I don't think they
16C
register it
is
until
outside.
after the fact.
Well,
I don't
the
think
regis, well,
That 11,
Well, he's
the
gotta get the
context
permit.
shows, yeah, that they have to have.
Why should they ask for a permit when the conditional use has been denied?
they had to fill out an application to even start the conditional use. The
Mhm.
Yeah, but
conditional
that's
use
not
has
this
to
one.
be started.
That's not this, under 11. That's different.
Well, I'm not sure that the application shall identify the antenna on the tower, blah, blah, blah. It's zoning and street address. The permit shall certify that when granted, when the conditional use is granted. In this case. And then, once everything's taken care of, then they get this permit, then they put this thing on the antenna. But this is just the entry, this is where you start. And you start and they say, okay, what do I got? I walk in, I don't know anything. Well, first, fill out this permit. You fill out the permit, they go,
But I
okay.
guarantee
you gotta
you
go
they
to
didn't
the-"
do that.
Well, I don't know that. I don't know that. You might be right.
Because there's nothing in the record that they did. It would have been
Well,
listed in the staff memo.
Well, they filled out,
No, it's just an application for conditional
for
use. That's all they
conditional use,
did.
because that's what pertains. I mean, I don't know if they did or did not. Yeah,
It doesn't say that they did, so I think we've got to assume that they didn't. Otherwise, it would have been listed.
I'm gonna ask for a break.
Yeah, me too. This is a conundrum that I had not even thought about, I must tell you quite frankly.
You
I
said
was
we were
simply
gonna-
plowing
We just
ahead.
don't have the
No, you said spirit of
background
discussion,
of,
so you're
of,
in the middle of it.
our new
Now we are.
member in
Practical.
the tiered thing. I think it's great, but I'm gonna ask to be excused.
How
because-
about 15 minutes?
Yeah, or
We're
even
taking a 15-minute break?
Taking a